just a small caveat that we aren't medical professionals, so this is entirely from an employment law perspective. So I'm Simran Lally, as you all probably know, and I am a solicitor at Grantsaw based in the Greenwich office. I work with our head of department, Michael Pope, who's on today's call and will be helping with the questions afterwards, and paralegal Lauren Smith. So just a bit about the work that we do. We act for employers on both contentious and non-contentious employment law and HR matters, which includes defending employment tribunal claims. We advise on redundancies and restructures, TUPE, disciplinary and performance management matters, contracts of employment, staff handbooks and policies. So today's webinar does kickstart a series of webinars that we will be holding about discrimination in the workplace amongst other areas of employment law. The aim is to keep you all up to date of the ever-changing world of employment law and ensure that you're well equipped to deal with all eventualities as business leaders and HR professionals. So I did want to start our series with a COVID-free webinar, but it is quite difficult to park COVID to one side, given the huge impact it's had on the workplace and is likely to continue to have over the next few years. So just a brief overview of today's discussions. So I will talk through discrimination quite generally to give you an overview of the types of discrimination that there are and advise you of who is protected under the law. We'll then go on to look at long COVID, explore whether it may be a disability under the relevant legislation, which is the Equality Act 2010. And then we'll be looking at what adjustments may need to be made for employees with long COVID or similar health issues. And then we will advise of steps that you could take as employers to ensure that your employees are supported, they're treated fairly, and of course, practices that may result in discrimination claims are avoided. So discrimination is one of the fastest developing aspects of employment law, and it does have an impact on all areas of the employment life cycle, right from pre-recruitment through to termination, and in some situations beyond. So employers should be aware that unlike most other awards at a tribunal, there is no cap on discrimination compensation. Therefore, employers cannot afford to ignore this area of law, both financially and also it does come with quite negative reputational damage as well when you do end up on the receiving end of claims of this kind. So it is unlawful for employers to discriminate against their employees because of any of the protected characteristics. I've popped up the protected screen. Today we are dealing with just disability, but our future webinars will be looking at the other 8 characteristics. So there are different types of discrimination and other lawful conduct that apply to most of these protected characteristics and sometimes all of them. So this includes direct discrimination, indirect discrimination, harassment, victimization, and instructing, causing, inducing, helping discrimination, and then discrimination arising from a disability. So the two that I'm sure you've come across or heard of is direct and indirect discrimination. So direct involves an individual being treated less favourably because of one or more of the protected characteristics, whereas indirect is where an employer has either some kind of practice or policy that puts a particular group at a disadvantage. So the classic example, which I'm sure you've heard, is where an employer may require their employees to work full-time. And this kind of requirement could disadvantage women as a group, since women in society are still they still have the greater responsibility of domestic and childcare responsibilities, and they're more likely to either want or need to work part-time. So with that, unless the employer can objectively justify the need for them to be full-time, the requirement could be indirectly discriminatory against women with childcare responsibilities. So moving on to long COVID. So I'm sure you've all heard it being called different names. Some people call it post-COVID-19 syndrome, and I'm sure there'll be a lot more nicknames coming about. But the Office for National Statistics did report last month that around 1 million people in the UK confirmed that they were experiencing long COVID symptoms. There's no universal definition at the moment, but the NHS does have up some common symptoms on the website, which includes extreme fatigue, insomnia, shortness of breath, problems with memory and concentration, is what they call brain fog, heart palpitations, dizziness, pins and needles, and there are other common symptoms such as joint and muscle ache, lung damage, and there's some lesser symptoms such as loss of taste and smell. So for those that self-reported long COVID, it was found that it was greatest in people aged 35 to 69, females, those living in the most deprived areas, those working in health and social care, and those with a pre-existing activity limiting health condition. So moving on to the key question of today's webinar, which is, should employers be concerned that long COVID could amount to a disability? The short answer is yes, but I will take you through why and what you can do as employers to support your employees. So just taking a step back to disability, the definition is found in the Equality Act 2010, which I've popped up on screen. So some conditions do automatically qualify as a disability. For example, there's cancer, HIV infection and MS. In all other cases, the individual must show that they satisfy this definition to be able to be protected from discrimination because of their condition. So for today, the most effective way for us to determine whether long COVID is likely to be classed as a disability is to break down this definition into 4 stages. And just bear in mind throughout that this test will need to always be applied on a case-by-case basis, as long COVID is one of those conditions where everybody's experiencing different symptoms and it is affecting everybody differently. So the first element of the test is, does the individual have a physical or mental impairment? So you'll hear me say this throughout, but there is no statutory definition as to what amounts to a physical or mental impairment for the purposes of the Equality Act. But the key point here is to focus on the effect of the impairment on the individual rather than how it was caused. I do think, given the symptoms of long COVID, which I had up on the previous screen, it is likely that some or all of these could be classed as a physical or mental impairment, especially those symptoms such as breathlessness, lung damage, joint and muscle pain, and exhaustion. Maybe the less kind of clear issues are the next 3 parts of the test. So number 2 being, does the impairment have an adverse effect on the individual's ability to carry out normal day-to-day activities? So again, this isn't defined in the Act as to what amounts to normal day-to-day activities, but we do have some guidance on this. So it is essentially what it says. So it's things that people do on a regular basis, day to day, and the examples include things such as reading and writing, having a conversation, travelling via various forms of transport, and taking part in social activities. Again, I do think some of the more serious symptoms could definitely have an effect on an individual or an employee carrying out their daily tasks. So as an example, joint pain or fatigue could mean that the individual is unable to travel to work, unable to work the same hours they used to. They may not be able to complete physical work, or if they're sitting at a desk, it may not be able to sit there for long periods of time without rest or without getting up to have a break. Number 3 of the test is that effect substantial? So substantial does mean something that's more than minor or trivial. So whether they are able to establish that the effect is substantial will again depend very much on the severity of the symptoms. It could be that symptoms such as partial loss of taste or smell may not necessarily be considered substantial, whereas the more serious ones such as lung damage, significant muscle and joint pain, exhaustion, and some people have reported mental health issues, these could be substantial for some employees and result in them having some time off work. And then the last element of the test is that effect long term? So long term under the Act, it does mean that it will have a long term effect if it's lasted 12 months, is likely to last for 12 months, or is likely to last for the rest of the life of the person affected. And just note, it is judged at the time of any alleged discrimination. So this one is difficult because although it does seem like long COVID has been around forever, it hasn't really been around long enough for us to know whether the symptoms will persist and for how long. And we are unsure still of how effective any rehabilitation might be or any treatment. So it is unlikely that we're going to know for certain until there's further research on this or until some further time passes and it's monitored. So in my view, though, it is likely that a lot of the serious symptoms may well have a long-term effect. But again, it's all dependent on whether treatment is forthcoming and if it's easily accessible. With this, I know we've been through the test just for long COVID, but it is important to know because of those who are reporting long COVID do already have pre-existing health conditions. Other conditions a long COVID sufferer already suffers from may be relevant here because cumulatively the two may amount to a disability, even if the employee or individual wouldn't necessarily qualify as disabled just on long COVID itself. So that's something important to keep in mind if you are speaking and discussing the issue with these employees. So next, looking at how employment tribunals will approach long COVID, it is difficult because, again, it's early days. I'm not aware of any cases that have been through the tribunal just yet in relation to long COVID, although we are starting to see some cases come through on COVID generally, more about dismissals, mask wearing, health and safety issues. But one way to look at it is to compare long COVID to similar health conditions. And there have been some articles reporting that long COVID can be similar to ME, which is also known as chronic fatigue syndrome. There is an example case in 2009 where an ME sufferer, whilst their condition worsened and then got better over a period of time, it was found that their symptoms were consistent and persistent, and so they did meet the criteria of being substantial and long-term, and therefore they were protected under the Act. So all employers with staff who are suffering from long COVID should be mindful of the possibility that they may have a disability, but again, this really is dependent on the severity and duration of the effects. This means that treating a long COVID sufferer less favourably because they have long COVID, or for example, they have high levels of sickness absence or are unable to fill their roles, could amount to direct disability discrimination or discrimination arising from disability. So if an employee is disabled, the employer does have a duty to make reasonable adjustments for them. I'm sure you've all heard of the term, but it is quite a wide area where an employer does have a positive obligation. So it isn't necessarily for the employee to bring this up or suggest them. It's for the employer to consider if any adjustments can be made to alleviate any disadvantage suffered by the individual in the workplace. What is reasonable, again, will depend on the situation. Each employee is different and obviously each business is different. But when looking at what is reasonable and appropriate for that particular individual and the company, you'll need as employers, you should really consider if the adjustment will firstly remove or reduce the disadvantage for the person with the disability. You should consider whether it's practical to make this adjustment, consider whether it's affordable for you as a business, and then lastly, always consider whether this adjustment could actually harm the others in the office, so be aware of their health and safety. So the crux of reasonable adjustments is to really level out the playing field and remove barriers. So the onus, as I said, is not on the disabled person, it is for the employer. So whilst it is all done on a case-by-case basis, there are some examples for long COVID sufferers. So the first being flexible working. So again, the example is where you have somebody who might be suffering from fatigue or muscle and joint pain. So you could either be reducing their hours to allow for rest breaks, or so that they're working shorter hours, or that they're missing the busy commute in the morning, so they might be starting a bit later. But flexible working can also mean where you've got employees returning to work. You might consider for long COVID sufferers that they actually work remotely for a longer period of time than others, because it may be more comfortable for them and it may be easier for them to take naps or rest breaks when they're at home. The next example could be changes to the working environment. So this can include a range of different things. It could be somebody who is an office worker and that they're sitting at a desk, so they may request that they have a more comfortable desk chair, standing desks are kind of the new thing, or footrests. It could also be in a warehouse where their workstation is adapted to suit their conditions. Next, you could actually make changes to a job role. So this is sometimes the less popular reasonable adjustment, but for example, if somebody is returning to work and they're returning to a busy and hectic environment where their targets and KPIs are exactly the same as when they left, they may request a temporary relaxation of these targets just for a short period to enable them to return to work successfully and get back into the swing of things. In nicely with this is mentoring and counselling. So if somebody is off for some time and they come back to work, they may need somebody to either just speak to about the workload and get back used to their role. So this could be somebody in their department, their team, somebody a bit more senior, or it actually could be counselling from an external source. So for employers, it's always important to note that a failure to make a reasonable adjustment can be classed as a form of discrimination in itself. So it is definitely worth taking the time to consider what works for your employees and what will work for your business. You could also, for reasonable adjustments, because these are new to employees and new to employers, it could be a trial period is appropriate to test out, are they working for both parties? And then, as well as reasonable adjustments, there are various practical steps that you can take to support employees who are suffering with long COVID. So disability aside, these are steps that you could take anyway, just to ensure that you do have a fair, kind of a safe environment for employees to work in. These again need to be assessed on a case-by-case basis and discussed in conjunction with the affected employees. So examples of practical considerations can include proactively managing their sickness absence. So even with COVID aside, if you've had an employee off work for some time, you should be having return to work meetings and exploring whether there's any pattern of intermittent sickness absence or long-term sickness absence. And if appropriate, you can refer employees to occupational health to gain a better understanding of the condition that they're suffering from. So this one ties in. So return to work meetings are always very, very useful. They can involve you discussing with the employee whether they're well enough to return to work, and this can be the opportunity to approach the topic of reasonable adjustments or support that they might need. So you can ask them if they're genuinely well enough to be at work and see if they have any suggestions for reasonable adjustments. You could, as mentioned above, you could also refer them to occupational health if that's necessary, and obtaining medical reports is always useful because obviously as employers you're not expected to be medical professionals and diagnose somebody, but you should be alert as to when to signpost them to these external sources. And you can consider carrying out, whether this be at home or in the workplace, a risk assessment. So this was being done, long COVID aside, just for COVID in general. I know a lot of employers were carrying out risk assessments of their workplace to ensure that it's safe for their employees to work. But if you've got somebody working at home alone, it may be a good time for you to assess how are they working in terms of, do they have the right setup? Are they supported? Do they have regular check-ins with people? And then, whilst you probably do make employees aware of external support when they start their role, maybe with their contract of employment or handbook, you offer them some benefits in that sense, but it is a good time to remind them of what's out there, particularly if they are just returning from work from sickness absence. It might be a good time to let them know if you do have EAP available, if you've got a counselling helpline, or if you do have any private medical insurance that they could take advantage of. Again, with this, so insurers have also started to amend their policies with regards to long COVID, and they have been letting employers know their approach to this. So it's always a good idea to, if you do have private medical insurance offered, that you see what your insurer is saying about these types of claims. And then education is obviously always key, not only for your managers, but for your staff as well. So it might be helpful to educate all your employees about long COVID and its symptoms and effects. It can open up a dialogue so that colleagues are educated about it and they can be supportive of each other. It can also assist with reasonable adjustments that might be made. So for somebody who's just suddenly got a new desk chair, others may be wondering, why has this person got that and I haven't? So being educated on long COVID and the symptoms and the effect it does have on people, it can sometimes prevent bullying in the workplace because of special treatment. And it is just generally better to educate everybody rather than those just at the higher level. So to wrap up the webinar, I have popped up some important points and key takeaways on the screen. The important point to note is obviously long COVID is a new medical condition, so both employers and employees are learning to adapt and to live with it at the same time. So there are understandably going to be some issues which arise. I think the most important thing that you take away from today's webinar is to not have a blanket approach to employees. As you probably saw from the list of symptoms and from the examples of reasonable adjustments, it's affecting everybody differently, and employees are going to require different levels of support and different kinds of support. So moving on, if you do have any concerns, it is always good to seek legal advice before you either approach your employees about reasonable adjustments or before you implement them. And if you are in need of a return to work policy, a sickness absence policy or similar, do just let us know. So we are going to have a short Q&A session now. So Michael and I will be having a look at the chat box to see if we have any questions. But as I say, if you have anything that's more specific that is confidential, you can feel free to email either of us, and then we will be answering them directly by email.